Okay, before Rick begins his presentation, as a member of CACOR's Board of Directors, I have a brief announcement that I'd like to make. For the last 9 or 10 months, advancing our group's intent to undertake and participate in more advocacy initiatives, a couple of CACOR members have been drafting a Charter of Climate Change Rights and Responsibilities. This document includes 7 recommendations directed to every level of Canadian government and to individuals, asking them to make needed changes on how we can live with less environmental impact on the global ecosystem that supports our lives. This initiative, led by David Pollock and Jeff Passmore, has now been finalized and will be released tomorrow, January the 20th, to the press, politicians, and hundreds of environmentally focused organizations. Many CACOR members have already received an advance copy of this document, and tomorrow it will be posted on CACOR's website for everyone to read and support. We would really appreciate it if members could actively circulate the Charter to friends, local media people, and organizations to which you belong. And now for my introduction to Rick. On the screen is a detailed biography of Rick's background as an environmental lawyer who has worked for 35 years with the Toronto-based Canadian Environmental Law Association, or CELA. My contact with Rick and CELA occurred in 1989 when an Ottawa area public interest group, the Wetlands Preservation Group, of which I was involved, registered a request to the Ontario Municipal Board to deny a developer the ability to construct a golf course within the provincially significant Class 1 Constance Creek wetland. The developer intended to undertake, as part of his housing and golf course development, clearing of wetland vegetation right to the stream edge of Constance Creek to provide unique challenges to golfers. Upon contacting CELA for legal representation at an approaching Ontario Municipal Board hearing, Rick was assigned, or maybe he volunteered, to provide us with free legal services as needed. There were many delays and detours involved in our appeal, and it was calculated that all told, the overall cost of everybody's participation, that's not necessarily they were paid to or there was an expense to it, in our 2-year-long appeal process was about $2 million. Since the 1990s, Rick has maintained his involvement with CELA, and with his personal knowledge of federal, provincial, and municipal legal systems, he has also become a professor of law at Kingston's Queen's University and Peterborough's Trent University. And with that introduction, I turn the day over to Rick.
Great. Well, thank you very much, Phil, for that kind introduction. And good afternoon, everybody. Let me at the outset start sharing my screen. Just bear with me here. Oops, I went too far already. And I'd also like to thank at the outset the CACOR organizers. It's an honor and a privilege to be here today and to participate in this discussion on climate change and the law. I will say at the beginning of this slide deck, I have to apologize for it in advance. It's pretty boring, not because it deals with the law, it's because it doesn't have any sound effects or special or fancy graphics. And that's because my kids haven't showed me how to do that fancy stuff on PowerPoint yet, so you have to bear with me. So with that introduction, let's get underway. And I start off my presentation with a quote from the Chief Justice of Canada, Richard Wagner, in a fairly high-profile case that the Supreme Court of Canada decided last year. And this was 3 appeals in the Supreme Court of Canada dealing with the Greenhouse Gas Pollution Pricing Act, which I'll speak about in more detail later on in my presentation. In the course of rendering judgment, the Chief Justice provided this factual statement that climate change is real. It is caused by greenhouse gas emissions resulting from human activities, and it poses a grave threat to humanity's future. that is not really a new or novel or groundbreaking observation by the Chief Justice. Scientists and others have been saying that for years and decades. But we liked seeing this in the Supreme Court of Canada's judgment, because it really recognizes for the first time at the highest court that climate change is real and that effective action needs to be taken expeditiously in order to deal with this existential threat. I will also say that wasn't the question to be decided by the Supreme Court of Canada. It was not there to adjudicate whether or not climate change is real. Instead, it was dealing with a much more mundane issue, which was whether or not the greenhouse gas legislation was actually within the constitutional jurisdiction of the federal government. And I'm happy to report that the majority opinion said yes. So we do have a carbon pricing law at the federal level, and we'll talk about that in more detail. I just think this is a good quote because it really sets the stage for everything else I'm going to talk about today. And I guess in the interest of full disclosure, I should mention that I represented 3 interveners in this case, and I can report that they're pretty happy with the outcome, and they're really happy to see that the Supreme Court of Canada has recognized climate change as a fairly serious threat that needs to be dealt with effectively by all levels of government and all persons in Canada. And I thought it might be useful perhaps to have a quick word from at least my sponsor, the Canadian Environmental Law Association. Phil knows us well based on our past work with him and his group, but maybe not all of you are familiar with who we are and what we do. So I thought I'd spend a moment or two just to make sure we're all on the same page. But basically, we're a public interest group that was established in 1970. So I guess that makes us middle-aged. We're now 50 plus years old. And for the past 5 decades, we've been going to bat in the courts and in the tribunals on behalf of our client communities. These are generally low-income persons, vulnerable or disadvantaged communities, First Nations, etc. And as Phil mentioned at the outset, our legal services, our legal representation is provided to our clients for free. That's because we're funded and operated as a specialty legal aid clinic. I guess you could say we're a one-trick pony. All we do is environmental law, and we do whatever it takes to represent and defend our clients' interests. And we do that by using all the legal tools at our disposal. We bring civil actions, we do judicial review applications, we do interventions, we do appeals, we do private prosecutions. Again, as I say, we do whatever it takes to safeguard the interests of our clients and their communities. And it's also probably worth noting, especially in the climate change context, the nature of our clientele is kind of significant and relevant in the sense that it's been well established that low-income folks and disadvantaged communities are often disproportionately impacted by the effects of climate change. It's been often said that these communities often feel the impacts first and worst. They don't have the wherewithal or the means to really safeguard themselves against some of the adverse impacts. So that's the reason why we are involved in climate change litigation and climate change policy development in this country. I think I'll end the infomercial about CELA, and we'll move on to the subject matter of my presentation today. So this is the roadmap for the topics and issues that I intend to cover. You'll see, first of all, I'll briefly review the different types of climate change litigation. There are different categories of climate change cases that are being brought here in Canada and elsewhere. So we'll lay some of the conceptual groundwork as to the theories of liability that are being advanced in those cases. And then we'll look at some actual real-life examples of climate litigation here in Canada, the United States, and other jurisdictions around the world. And once we finish that romp through some of the leading cases, then we'll look at some of the recent legislative developments that have either been passed or proposed in the context of climate change. So we'll get to that in due course. And then finally, at the end, I'll review some good online resources that you can access if you're interested in finding out more information about some of these climate cases and some of the recent trends and where these things are going. So I'll get to that momentarily. So I guess this brings us to the threshold question of why use the law at all in the climate context? And I think the short answer is it's because it's a tool that's in the toolbox alongside other tools like economic incentives, economic instruments, technology improvements, renewable energy advancement, that kind of thing. But I think there's a role for the law as well. It's not intended to displace or replace these other tools. I see it as a supplement to these other disciplines, these other areas that can collectively hopefully make a difference and result in some tangible progress in terms of climate change, mitigation, and adaptation. There are, as I mentioned, a number of different types of cases. They're usually advancing fundamentally different types of theories of liability. They're looking for different remedies. Obviously, the parties are different. Sometimes it's NGOs, non-governmental organizations suing government. Sometimes it's government suing big oil. So there's a whole grab bag of different types of cases, and we'll review them shortly. I guess I should give you my standard caveat, and that is what I'm about to cover is really just general legal information. It is not legal advice, and it's not a legal opinion. As we say, at least here in Ontario, if you need a legal opinion or legal advice, you better retain and instruct independent legal counsel. So I'll leave that with you. So I guess before I leave the slide, the essential takeaway point here is I think the law potentially is a good and useful and effective weapon in the fight against climate change and its impacts. I think it's also safe to say judicious use of the law and legal rights can help move the yardsticks down the field, so to speak. But having said that, I would also suggest to you that although the yardsticks are slowly moving down the field, we're still a long way from the end zone. It's still a long way from scoring a touchdown. So I think the bottom line for me is that if we want to, make some serious headway in terms of climate change mitigation and adaptation, we need to do more, we need to do better, and we need to do it faster. And I think the law can play a clear role in that. And in fact, as we'll see in some of the cases, using the law has resulted in some progress. But is it happening fast enough? Are we going far enough? I guess time will tell. So this is the first category of cases that I wanted to bring to your attention, again, at a sort of a fairly general level. And on that point, I should say this whole presentation is really a high level look at the legal landscape. It's kind of like Google Earth. We're taking a big view from the top. But in a few instances, we'll get into some of the litigation details and outcomes of some of the actual cases. But for the most part, this is going to be a high level review of these types of cases and what can be done, what can be achieved by bringing these kinds of lawsuits forward. So the first category that's on the screen right now are the cases that are attempting to ensure that decision makers are properly considering or taking into account climate change and its impacts now and down the future. And as I indicate in the first bullet point, there are laws here in Canada and elsewhere that specifically require decision makers to take climate change into account before large-scale projects are approved or given the green light to proceed. And if it appears on the record that the decision maker, whether it's a regulator, some approval body, maybe a minister of the crown or cabinet, if they didn't adequately consider climate change or climate change implications, aggrieved persons or concerned citizens might think about going to court to quash that decision and have the matter sent back to the original decision maker for further accordance or further consideration in accordance with the law. And so I'll get into an example of that down the road, but that's sort of like I wouldn't say it's an easy category, but this is a type of case that's, there are lots of precedents for this here in North America and elsewhere, and I'm sure there's going to be more opportunities in the near future to go to court to set aside statutory approvals or decisions that give the green light to big scale, environmentally significant, not climate friendly projects where climate change was either discounted, overlooked, ignored, or whatever. So there are cases like that. We'll get to one of them momentarily. And that brings me to the second big category of climate change cases, and those are tort claims, which are looking for redress or relief, some sort of judicial remedy to deal with harm arising from, climate change or activities giving rise to climate change. And I call these cases old-fashioned because tort cases are essentially rights to sue or theories of liability that have been developed by common law judges here in Canada, the United States, England, and elsewhere. And these theories of liability, these civil wrongs that are recognized by the courts, they were developed by judges long before legislatures started to enact specialized environmental statutes. So a lot of these tort rights to sue originated in the 1800s, early 1900s, before we had specialized environmental laws yet. The courts saw fit to create some theories of liability that would allow people who've suffered injury or loss or harm to go to court and get some compensation, some relief from the tort fees, or as we like to say, the wrongdoer. So I've put on the screen a few examples of those tort cases that have been developed at common law by judges. The first I think I put on the screen is private nuisance. And that refers to situations where a defendant's conduct has caused substantial and unreasonable interference with property interests. And nuisance can take different forms. It can include things like physical harm or chemical contamination of property, but it also can include things like interference with the use and enjoyment of property. The property itself may be fine, but the impact from some off-site activity might be interfering with a person's ability to use or enjoy his or her property. And where that occurs, you may want to go to court and seek some relief. Public nuisance is essentially the same thing, except we're dealing with nuisance impacts that are being suffered by a community at large, as opposed to perhaps a small handful of neighbors around a site, a noxious site of some sort. And we'll see, I provide an example of a case where cities are using public nuisance claims to go after big oil. So we'll talk about that in a minute. Negligence, it's a very important tort developed at common law. Basically, that refers to careless conduct by a defendant that results in foreseeable and direct harm to other people who the defendant knew or ought to have known would be adversely affected by that activity if they don't take due care. The three essential elements of negligence are that first of all, the plaintiff has to show that the defendant owes a duty of care to the plaintiff based on their proximity or their relationship. Second, you have to show that the defendant breached that duty, failed to do what reasonable people would have done in the circumstances, or failed to comply with regulatory requirements. And third, you have to show that the breach resulted in harm to the plaintiff. And if all three can be satisfied, then you may be able to sue in negligence. And it's an all-purpose tort. It's not environmental per se, although we use it in environmental litigation. But it's used in all kinds of things, whether it's medical malpractice or motor vehicle litigation, defective products liability. But the same three elements have to be demonstrated to the satisfaction of the court. Then finally, the final example of a common law tort that we use in the environmental context is trespass. We're talking about the common law of trespass. And that refers to situations where the defendant has caused or allowed a substance or a thing to, be deposited or to be put or to invade, upon someone else's property without their consent. And again, if that happens, the aggrieved landowner may be able to sue in trespass. And what we typically do in environmental litigation is, if we're representing the plaintiffs, which we do, we would try to plead all of these common law torts in the same statement of claim, because you never know which one is going to find favor with the court on the evidence. So we throw it all in, and hopefully you come out successful at the end of the day. And if you are successful, then the court would be able to grant you certain relief. It can award monetary damages to compensate the plaintiff for the harm that has been incurred. The court might be convinced to issue an injunction, which is, of course, a mandatory order compelling the defendant to stop doing something or start doing something in order to avoid the harm. And there's other relief that's available to the court. So conceptually, tort law is still around, still available to plaintiffs, including those who want to go after tortfeasors, defendants as a result of climate change related harm. So now we'll move on from the common law and then talk about causes of action or rights to sue or legal proceedings that are based on statutes that have been passed by one level of government or the other. And it probably comes as no surprise that there are a number of statutes, a number of laws that prohibit companies from undertaking deceptive or misleading public communications, for the purposes of trying to convince people to invest in their company or buy shares or stocks. And if that happens in the climate context, if a company has been misrepresenting or suppressing the climate science, or if that company has been failing to adequately disclose climate-related risks associated with its activity now and in the future, then it may be possible to seek monetary penalties either by a regulator or by the court. And I'll give you a couple of examples of real-life instances where that has occurred. And that brings me to the fourth and final big category of climate cases. And these are the ones where plaintiffs are basing their claim in part on international climate targets and timelines, such as the Paris Agreement, Glasgow, Kyoto before that. And these are the big cases that you often hear about in the media. You hear a lot of discussion about them. And some of the cases that I'm going to take you to that fall into this category, you probably already, you might be familiar with them. But basically the argument here from the plaintiffs is that this government or that corporation as defendant needs to take further and better action, or needs to stop doing certain things in order to meet the Paris goal of limiting temperature increases, as I indicate here, to hopefully 1.5, but hopefully nothing bigger than 2 degrees C. As people on this call know that, there's evidence indicating we're not anywhere close to meeting that, but that's the basis for some of these, I guess, the new genre, the new category of climate litigation. But these days, there seems to be a trend by plaintiffs to not only invoke or rely upon the Paris Agreement, but also to supplement or buttress that argument with reference to human rights conventions or human rights legislation or constitutional rights. There are a number of countries that include a right to a clean and healthy environment as part of their basic constitutional law. And where that exists, it's obviously a pretty useful thing to invoke in this kind of litigation. I put a reference in the second bullet point to the Canadian Charter of Rights and Freedoms. I'm sure most of you are familiar with it. And if so, you'll know that that charter, our charter, does not contain an express or explicit right to a clean and healthy environment. A lot of observers and commentators have suggested that maybe this is time to amend the charter and to include such a right, and it could be potentially pretty helpful in the climate change context if we can wave around a climate right or an environmental right like that. But for political or other reasons, the charter has not been amended to include that. So for the time being, or in the interim, we're limited to other rights. And some of these climate change cases that we're going to talk about here in Canada have relied upon Section 7 of the Charter, which guarantees everyone the right to life, liberty, and security of the person. Hard to have life anyways if you're living in a degraded environment. So the courts have been willing in some cases to concede that Section 7 does or could include a right to a clean and healthy environment, or that right is contravened if governments are allowing or approving activities that are contrary to that right. I will say though, although over the years a number of charter-based environmental claims have been brought, so far they have not been successful, mostly for evidentiary reasons. I think the court recognizes that a healthy, clean environment is inferred under Section 7, but so far people have not advanced or adduced the right type of evidence to convince a court to grant a charter remedy. That may change. The other charter right that's relevant in these kinds of environmental cases is Section 15, which prohibits discrimination on various prohibited grounds. And again, that's been the basis for some environmental claims, arguing that, you know, some folks like First Nations are experiencing discrimination because they're being subjected to impacts that wouldn't otherwise be forced upon, you know, richer or more well-off southern communities or municipalities. So the discrimination right, or the right to not be discriminated against, can sometimes be invoked in the environmental and climate change context. But we'll see in a few minutes that has met with some, shall I say, mixed success so far. So that brings me to the end of the legal theory. I hope I haven't bored you to tears with that. But now we're going to take a look at the real cases that have been actually brought, some successfully, some not, all around the world. What's interesting here is it's generally conceded that the first known climate case was actually brought in 1986. And since in the 2 or 3 decades after that, about 800 or slightly more than 800 cases were brought. But there's been a real explosion in climate change cases in the last 5 or 6 years. Almost 1,000 new ones have been brought based on some of the theories of liability that we just reviewed. Interesting to note that most of the cases that are now ongoing actually arose in the United States of America. Some people might say, well, that's because of the litigious nature of American society. I take no position on that. I think the better answer for the explosion of cases, particularly in the United States, is that people are now seeing firsthand the direct adverse impacts of climate change, whether that's extreme weather, fire, floods, drought, the list goes on and on. And so I think that has galvanized people into action. I think concerned individuals and environmental groups and even some subnational governments in the United States themselves have now seen the need to go to court to get some action moving and to get some relief against some of the deleterious impacts associated with climate change. So some of the cases that we're about to talk about arose in the States, but there are some good examples that have been, of climate cases that have been brought elsewhere, and some of them have been very successful. And we're now trying to emulate some of that here in Canada. But I don't want to leave you with the impression that it's really easy to bring a climate change case. It's not. Contrary, it's true. You know, if a government or a corporation is being sued on the basis of climate change impacts, those kinds of cases are very vigorously defended and very hotly disputed by the defendants. And they often, this seems to be a strategy used by almost all defendants who are on the receiving end of a climate change case. They'll try to bring all kinds of motions before the trial, before the matter is even heard on the evidence, trying to get the whole thing tossed out or terminated on a summary judgment basis. And so you'll see in a few moments, there are examples where defendants have brought motions to strike the claim in its entirety without a full hearing, without a trial, and sometimes that works. And when those kinds of motions are brought by defendants, they're usually based on the kinds of considerations that I've outlined in the first bullet point. Let's talk about justiciability, for example, and we'll see that has been a successful argument for some defendants. Basically, it's an argument that a climate change claim is not really appropriate to be decided in the courts. It's really a political matter. Leave it to the policymakers, leave it to the elected officials. You know, and if you think that these elected officials have not come up with a plan or a program or a policy that is sufficiently rigorous or doesn't meet the Paris targets, then you vote them out in the next election. You know, we call that ballot box accountability. So that's where some of these things should be decided, not in the court of law. So we'll see in a moment, there are instances where the courts have said, this is not the appropriate forum to be adjudicating this. This is a matter of, you know, public policy. Go have that public policy debate outside the courtroom. So that's what justiciability is all about, is that the subject matter of litigation is not appropriate to be adjudicated in a court of law. And that brings me to the next hurdle that litigants sometimes get faced with, and that is the whole issue of standing. That is essentially a question: does this person have sufficient status to sue? Do they have a right to sue? And so, for example, if you're going to use the common law as the basis for your claim, the common law basically requires the plaintiff to have what we call a 3P interest. You have to show that you have a personal interest, a property interest, or a pecuniary interest, an economic interest that's been adversely affected by the defendant's conduct. And if you don't have that, you don't have standing and you'll be tossed out. Now, having said that, the courts have recognized that in some limited instances, if there's an aggrieved person who's not willing or able to come forward, that it might be open to environmental groups or citizens groups, non-governmental organizations to come to court and ask for public interest standing to bring the matter to the court's attention and get a ruling. And in fact, last week, the Supreme Court of Canada held a 2-day appeal on a case that came out of BC, which involves the public interest standing test. When is it appropriate to give an non-governmental organization the opportunity to challenge administrative or governmental decision-making in court, even if they're not personally affected? And again, full disclosure, CELA was involved in that. We intervened in that case. The judgment is under reserve, so hopefully later by the spring we'll get some clarification from the court. I would say so far, recent Supreme Court of Canada jurisprudence has been pretty good. There is a good liberal public interest test that is known and has been used to allow people to seek relief with respect to decisions or matters in which they're not directly impacted. I hope and I expect that the Supreme Court of Canada will affirm that in its decision, but I guess we'll see in due course. So that's the standing issue. Then there's the cost issue. And this might be one of the most significant practical barriers to bringing climate change litigation, because first of all, these cases are complex. They're often heavily dependent on expert evidence. So if you're the plaintiff or you're the moving party, you have to, prepare and present all kinds of technical or scientific evidence from qualified people in their various areas of discipline. And of course, that's going to be responded to in spades by experts retained by the government or the corporations who are defendants in these kinds of cases. You're also going to need a lawyer. So unless you get CELA to represent you for free, or perhaps Equal Justice to represent you for free, you have to pay your own lawyer and your own experts. And in Canada, the general cost rule is costs follow the event, which is kind of a fancy way of saying loser pays. So if you bring one of these cases as a plaintiff and you win, that's great. That's a red letter day. Chances are you'll get some relief, and the court will probably order the defendant, the unsuccessful defendant, to pay you some or most of your legal or expert costs. That's great. But the converse is also true. If you bring one of these claims and you lose, well, you still have to pay your own lawyer and your own experts, but you will probably be ordered by the court to pay the defendant's legal and expert costs. And that can be pretty sizable in environmental cases. I'm aware of cases and have been involved in cases where adverse cost awards can mount up to hundreds of thousands of dollars, and in some cases millions of dollars. So there's a lot of money at stake in these things. You don't sue government or big oil on a lark or at the drop of the hat. You have to consider the strength of your case. What's your cost exposure? Can you afford to pay an adverse cost award if you lose? Those are the kinds of things that the plaintiff will have to take into account. The final barrier that I've mentioned here is causation. So again, going back to a tort example, if you're alleging that a particular fossil fuel company's emissions cause you harm, because your place burned down from a wildfire, or there was a flood or some other property specific impact that occurred, you're going to have to demonstrate to the satisfaction of the court on a balance of probabilities that it was this company's emissions, not somebody else's, but this company's emissions that actually was the direct cause of that harm. That's that's pretty tricky to do. And sometimes the defendants argue, well, you know what, I did, emit, X tons or gigatons or megatons of greenhouse gases into the environment, but my contribution is pretty small compared to, this country or that country. And how do you know that my emissions and, at this particular facility or facilities actually resulted in the harm that you're suffering half a continent away? So causation can be difficult, but there's lots of talk these days about attribution science. Scientists are getting better at drawing clear and robust connections between cause and effect in the environmental climate change context. Although I will offer a caveat on that. That's what a lot of people say, but I think the proof will be in the pudding is when these cases get adjudicated on their merits. A lot of the cases up at sea are still stuck in pre-trial preliminary stages, and the new science hasn't really been tested in court under cross-examination or through conflicting expert opinion evidence. So we'll see what I'm going to say. The jury's still out about whether some plaintiffs will be able to overcome this causation hurdle. I think things are improving, but I don't know if we're there yet. And as I say, those are the kinds of issues that get raised by defendants at a pretrial basis. Hopefully they can avoid having to go to court. And we'll see momentarily some of those pretrial motions to dismiss these actions are in fact successful. So at long last, we're getting to some real cases, real drama, real life. So this is an example of one of those cases where someone was trying to challenge a mega project, namely the construction of a third runway at Heathrow, where it appeared, at least to the plaintiffs, that the government decision makers had not properly or fully taken into account the additional greenhouse gas emissions that would result from increased aviation traffic on the third runway. So that's the essence of this claim. Well, I should tell you, in case you're wondering, you'll see the name of this case is Plan B Earth. There was another plaintiff as well, but I've embedded a hyperlink into this case citation. So if you want to find more information about this case, you can click onto that if you download a copy of this PowerPoint, and it'll take you right to a chart that gives you a really nice summary of what happened, and also includes the decisions and some of the pleading some of the legal documents that were generated during the course of this discussion or this litigation. And that's true for all the other cases that are in my slide deck. I've built in hyperlinks so you can actually read these cases in the summaries if you're so inclined, or if you're snowed in. So you'll see on this slide, there's an indication that the argument that the UK government did not properly consider climate change considerations in accordance with their international commitments under the Paris Agreement. That argument was not successful at first instance. The lower court said, no, we don't agree. You can win on that basis. But then the plaintiff's argument was successful on appeal. But then, of course, and predictably, that was appealed. And the plaintiffs lost in the Supreme Court on the grounds that the record reflected that the UK government and the minister in charge did, in fact, consider climate change, maybe not to the same extent that the Plan B folks would have liked, but it was taken into account, and they were not going to interfere with this decision to proceed with the third runway. I guess I'll say this is not Heathrow Airport that you're looking at. That's a picture I took at Toronto Airport years ago. It was the only airplane picture I could take, or that I could find on the computer. So we'll move on to a couple of the tort cases. Again, these are the civil wrong cases that I talked about earlier, and I've put up a couple of examples here where tort law has served as the basis, in whole or in part for the claim. So I put in reference to the San Francisco versus British Petroleum case. Again, you can click on that hyperlink if you want to read more information. But basically, this got a lot of people's attention. This was one of the first actions that were brought a few years ago against, I think it's 5 named fuel companies, like the big 5, based on public nuisance. And basically, the city wanted the court to order these defendants to pay into a fund that was going to use to help build bigger and higher, seawalls to help safeguard against rising sea levels that are attributable to climate change. And as I indicated here, another city in California, Oakland, brought a similar claim. But if you click the a little case citation here and you go to the case summary, you'll see that this one's been bogged down for years with pretrial motion after pretrial motion and then decisions and then appeals. These things don't happen quickly or overnight, which is unfortunate because we don't have a lot of time to play with, I would say, in the climate change context. We need to get moving. But I guess that's one drawback of using the law. The law, as I like to say, the wheels of environmental justice sometimes move pretty slowly. And it may take a while to actually get a decision on the merits, and then you got to go through the appeal process, and then hopefully you win at the end of the day. On the slide, I've also put on reference to the Sharma case in Australia. That's where some young plaintiffs went to court seeking an injunction against the Australian government. They were concerned that a mega coal mine expansion was going to exacerbate climate change by, allowing more coal to be dug up and burned for fuel. And so they started a class action to get that injunctive relief. And this was a fairly significant ruling. The court decided last year that, in fact, the government did owe and does owe a duty to take reasonable care to avoid personal injury to children as a result of climate change or decisions related to activities that might result in climate change. So that's a kind of interesting wrinkle or expansion of that duty to care component of negligence that I talked about earlier. But this case is still going on. The court has not actually ruled whether this duty has been breached in this case or might be in the future. So we're going to continue to watch this one. But it was a very interesting legal development. But what happens on the merits is yet to be determined. Then we'll come to, very quickly, the consumer and investor cases that have been brought against companies. The first one is Ramirez and ExxonMobil. And that's where this plaintiff filed a class action alleging that this company had engaged in securities fraud because they had misled the public, made false statements about climate change, and didn't fully disclose climate risks associated with the investment and the activities planned or undertaken by ExxonMobil. What happened was, after these folks bought some stock, then ExxonMobil announced that, well, you know what, we might have to write down the value of some of our assets, and some of them might even be stranded, which of course caused a bit of a loss in value for the shares, and these folks want their money back. So we'll see what happens with this one. This is another one that's way bogged down in pretrial preliminary stuff. Who knows what's going to happen? The other example I've put on the slide is the Commonwealth of Massachusetts versus ExxonMobil. It's a similar kind of claim, but it's being brought not by aggrieved investors, but by the Massachusetts Attorney General, who's bringing an action under consumer protection law, and again, alleging that this company engaged in deceptive practices and didn't fully disclose climate risks. So again, now underway, bogged down procedure, maybe get a result sometime soon. So this is the final category or final type of cases I want to talk about today, and these are the big ones. These are the high-profile ones that get a lot of attention in the press, in the media, on the internet, by policymakers, and for good reason. Some of them have been very successful, and some of the cases that I'm going to talk about here in Canada have tried to emulate that success. So the first one is Urgenda. It started a couple of years ago, but the Supreme Court decision wasn't rendered until a couple of years ago. But this is a really important landmark case that a lot of people point to and rely upon. Basically, Urgenda is a non-governmental organization that argued that the Dutch government's greenhouse gas reduction measures, the policies, the plans weren't good enough, and thereby contravening the human rights of people living in the Netherlands. And all levels of court agreed with that, including the Supreme Court of Canada, I keep saying Canada, the Supreme Court of the Netherlands, and they ordered the government to reduce greenhouse gases by a sizable amount compared to 1990. Now, I know the inevitable question, well, what happened? Because they were ordered to do so by the end of 2020. My understanding is that further measures were announced or pursued by the government, but whether or not they result in 25% reduction, I don't really know. I guess I'd have to click on the little hyperlink to find out. But it's this is a good example of holding the government's feet to the fire and having a court require them to do more and do better. So a lot of people like this decision. In fact, that brings me to the second case on this page, Emilio de Fosse. This is the Dutch wing of the Friends of the Earth group. And they basically took the agenda outcome, the agenda decision, and they wanted it to be applied to corporations themselves, private companies that are undertaking activities that are resulting in climate change. And that argument was successful. As I indicated on the slide here, the court ordered the Shell Company, the Royal Dutch Shell Company, to undertake greenhouse gas reductions in the amount of 45% in the next several years compared to 2019 levels. Now, no surprise, that's under appeal by Shell. But in the meantime, things are rolling. I read a few weeks ago that the plaintiff in this case has now sent demand letters to 30 other companies operating in the Netherlands, indicating that you now need to reduce your greenhouse gas emissions by this much by this time frame, and if you don't, we're going to start litigation against you. That's what a demand letter is. It's do what we say or we're going to sue. So we'll see what happens. These two cases have, again, generated a lot of attention around the world, and a lot of ink has been spilled talking about how they could be used in other jurisdictions. So speaking of other jurisdictions, here is what we've done so far in Canada. I call them the Made in Canada cases. And so I've identified 4 big cases, again, that have generated a lot of attention here in Canada, especially among the environmental bar. But the first one is the Anjou case that arose in Quebec. And basically a non-governmental organization filed a class action on behalf of Quebec citizens who are 35 years old or younger. I guess that's their definition of youth. I have to say I'm long past that milepost. But the essence of the argument from the foundation on behalf of young people is that the activities, the actions, the policies and plans undertaken by Canada to combat climate change were all inadequate and breached their rights under the Canadian Charter, Section 7, like we just said, as well as the Quebec Charter of Human Rights. I guess as an aside, I should indicate to you, if you don't already know, when you bring a class action, you don't start it automatically or as of right. In most jurisdictions like Ontario and Quebec, you have to get judicial permission, authorization, certification to allow it to go forward. You have to convince the judge that this is a good case to bring forward as a class action. And the motions judge here said, I recognize that this claim is justiciable. It can be brought in the court, but the motions judge refused to certify for other reasons, some of which had to do with the definition of the class, et cetera. And so that was appealed by Anjou. And about almost exactly 4 weeks ago, the Quebec Court of Appeal released its decision, and it upheld the refusal to allow this to go forward as a class action. But it went on to also say, and in addition, the claim's not justiciable. This isn't a matter for the courts. So that's a very recent decision. I don't know if you're going to seek leave to appeal to the Supreme Court of Canada. I suspect that that might be something that they're contemplating, but the deadline for doing that has not expired yet. So this is one to watch. I would make the same observation with respect to the LaRose case. This is a situation where some 15 youths, in this case, they were really young people, who sued Canada and again argued that the federal policies, programs, plans with respect to climate change amounted to climate inaction, and that contravened their Section 7 and Section 15 rights. And they made the additional argument that this contravened something known as the public trust doctrine. I don't think I'll get into it now in the interest of time. But in any event, as I indicate on the slide, the Canada brought a preliminary motion to strike this claim, and that was successful. The judge struck it out on the basis that none of this had disclosed a reasonable cause of action, and it's now under appeal to the Federal Court of Appeal. We'll see what happens next, so stay tuned to this one. And then we turn to a case coming out of BC where Indigenous persons representing First Nation communities sued Canada on the basis that the Canadian climate change plan, approach, et cetera, not only didn't meet the Paris Agreement, but also violated their constitutional rights and human rights. Again, specific reference to Section 35 of the Constitution Act, which recognizes and affirms existing treaty and Aboriginal rights And the argument here is that the impacts of climate change on the ground are adversely affecting their ability to exercise those rights. Not surprisingly, motion to strike was brought by Canada, and it was struck down in no uncertain terms by a motions judge who basically said this whole dispute is inherently political, it's not justiciable, and terminated the litigation. That's now under appeal, so we'll see what happens there. So I've been giving you sort of a litany of bad news for Canadian cases where people have been tossed out unceremoniously at a pretty early stage. But there is one glimmer of light. There is one case that's going forward, and a lot of people are watching this one closely. And this is the Mathur case here in Ontario, and that's where 7 young people filed a legal application alleging that Ontario government's climate, activities, measures, etc., contravene their rights under Section 7 and 15, and they refer to things like the decision of the current provincial government to repeal the provincial cap and trade regime that had been established years ago. So, no surprise, the Ontario government brought a motion to strike this down, but in 2020, the court ruled that this was justiciable, and it's now going to go to a full hearing in September 2022. So that's this fall. That's worth watching. We'll see what happens, and I'm sure there'll be inevitable appeals in any event. So I'm mindful of the time. I'll try to wind it down as quickly as I can. So far, we've looked at cases where the court said climate change is not really a matter for the courts, it's really a matter for legislatures to act upon. So I wanted to spend a couple moments talking about some of the things that the Canadian Parliament has done in the climate change context, and then we'll move on. So I mentioned the Greenhouse Gas Pollution Pricing Act already. That's the federal legislation that sets a minimum floor price or a backstop for carbon prices across Canada. The provinces are free to set their own carbon prices, but they need to be at least as good as what is the federal backstop, which some people would say is too low in any event. And as I mentioned, this legislation was subject to a constitutional challenge by Ontario, Alberta, and Saskatchewan. And ultimately, the Supreme Court of Canada upheld the constitutionality of the law, said that the feds did have jurisdiction to pass this law. So it'll be around for a while, but a lot of people are not happy with it. I would make the same observation with respect to the 2019 Impact Assessment Act. And again, if you click on these hyperlinks, it'll take you right to the legislation. But that's our federal environmental assessment law that was passed by Parliament back in 2019. And it includes a couple of interesting and new provisions that didn't exist prior in prior versions of federal EA law. And one is the requirement to consider the extent to which a project may help or hinder Canada meet its climate change commitments, things like the Paris Agreement. These are now, that consideration is now explicitly a factor to be addressed during the information gathering stage and during the decision-making stage when the minister or the cabinet are making decisions about whether or not this mega project or that mega project should go forward. They now have to direct their minds to what does this mean for climate and Canada's climate conditions or commitments. I put in the parentheses here, APCA, that stands for Alberta Court of Appeal. Alberta and several other provinces don't like this legislation either at the federal level. They say it's an unwarranted and unconstitutional intrusion into provincial jurisdiction over natural resources. So last year, the Alberta Court of Appeal held a judicial reference on the constitutionality of this act and the regulation under the act. I was involved in that case. We argued it for a week last February, and here we are, January 2022. We still don't have the decision. I guess it's possible that the Alberta Court of Appeal may decide that the act, including this new provision about climate change, are unconstitutional. And if so, I'm pretty sure there's going to be an appeal to the Supreme Court of Canada, and we'll drag things out a little bit longer. The final thing I wanted to mention in terms of legislative activity is the new bill that was passed last year called the Canadian Net Zero Emissions Accountability Act. It basically requires the federal government to achieve a target of net zero by 2050, and the government has to, set a number of interim targets to get us there, and also has to report to us on how well or how poorly they're doing in terms of meeting these targets. And that's probably a good approach. This got a lot of hype, got a lot of attention. Although I'm mindful of the fact that this was tried about 15 years ago at the federal level. We had something called the Kyoto Protocol Implementation Act, which similarly required Parliament to set targets and report upon, success or lack of success in meeting them. The government of the day, stopped reporting. A public-minded individual went to federal court saying, you're mandatorily obliged to report on this stuff. And the federal court in that case said, this is not justiciable. If you want to hold somebody accountable for not doing a report required by law, you vote them out. This is a surprising decision to me, but nevertheless, it's there. And I'm wondering if the same argument might be raised if, for whatever reason, this government or the next government, stops complying with the targets and the obligations, the duties in this legislation. There is that precedent that says, that's a matter, to be dealt with in the political domain, not the legal domain. I'll go through this very quickly. I've talked about some existing laws, but some people have questioned whether or not that's, again, going far enough, fast enough. Are there other things, other pieces of legislation that could be introduced or amended that would really expedite action and ensure accountability in the climate change context? And so I put a few examples of some of the proposals that people have been kicking around. One you hear about quite a bit from the Biden administration is to build back better legislation aimed at infrastructure and energy projects. So the theory here is if we are going to, as we start to plan our recovery from the COVID pandemic, we should use this as an opportunity to really, again, move the yardsticks down the field, expedite clean energy, wean ourselves off fossil fuels, et cetera. So we need to do that. Some people have argued that we need better, more effective, more stringent securities regimes to make sure that corporations do fully disclose climate risk. Some people have also suggested banks are, of course, federally regulated. Maybe we need some federal action to compel lending institutions to actually come up with and implement appropriate and effective net zero plans. These are the folks that, of course, are lending money to allow oil sands developments and other things to proceed. One thing that's going to be getting a lot of attention in the coming weeks is this proposal to entrench a public right to a clean and healthy environment, not in the Charter, but in the Canadian Environmental Protection Act, which is our main national anti-pollution law. And I note here that carbon dioxide is already listed as a toxic substances for the purposes of CEPA, so is methane. And if we were to entrench a public right to a clean and healthy environment in that statute, I think that would be helpful. I think we could use that as a, I don't know, hammer is probably not the right term, but use that to force further and better regulation of sources of greenhouse gas emissions, whether they're stationary or mobile. But Parliament, let me back it up. The Prime Minister has recently sent a mandate letter to the Federal Environment Minister saying, among other things, this is your priority. During this term, you are going to introduce in Parliament an amendment to CEPA that would build in a public right to clean and healthy environment. So that's going to be done. Whether or not it's going to be done effectively, I guess remains to be seen. The final thing I'm going to mention here is the undertaking legislative reforms that make it easier for governments to recover climate change related expenses or costs that they're incurring as a result of, fixing roads and, fighting fires and rebuilding communities. And I put a reference here to the special BC legislation that was enacted a long time ago to facilitate BC's attempt to go after big tobacco and recover healthcare costs as a result of smoking that are promoted by these companies. So that's an interesting precedent, and it might be things from that legislation that we could lift and use in the climate change context to make it easier for governments to go after persons or parties responsible for some of the worst greenhouse gas emissions. So I'm going to take a breath shortly. This is the next to final slide. This is the list of references and sources that you can investigate if you want more information. And these are all great. These are good annual reviews of what's going on the climate change litigation front. But I would highlight for you the very last one, the climate change litigation database. Again, if you click it, it'll take you right there. And you'll see the opening page is divided into both climate change cases in the United States, which is the bulk of cases, and then another database of all the other cases around the world, including Canada. And if you go through it, it's quite a phenomenal resource because it provides nice, concise summaries of what's going on. Some are more up to date than others. but they also give you access to the decisions, the motions, the pleadings, et cetera. So if you want more information about any of the cases I've talked about, this is where you're going to go. And I highly commend it to you. So I will take a breath. I will conclude my presentation on this slide. I thank you for your kind attention, and I welcome any questions or comments that you may have. I'll remind you that don't cross-examine me. I'm not under oath at this time, but I'll do my best to answer your questions. And so with that, Phil, I'll send it back to you. And I'm going to stop screen sharing.
Okay. Wow. Lots of things to digest. And we've got 11 different questioners. We don't know whether we'll get to everybody. But we've got Bill Pugsley, Dave Doherty, Vic Buxton, Jeff Strong, John Hollins. Most of you have already had confirmation, and I've told you who you will follow. But Bill Pugsley is going to be first, and then Dave Doherty, and then Vic Buxton. So, Bill, you're up.
Okay, thanks, Phil. Thank you very much, Rick, for your presentation. My question is about the mandate letter to the Environment Minister from the PM, where he's asked to introduce legislation to require the development of an environmental justice strategy and the examination of the link between race, socioeconomic status, and exposure to environmental risk. And my question comes because I'm a retired meteorologist, and for many years in meteorology, which is a federal mandate, unlike health and environment, which are primarily provincially led mandates, except where there's an international or interprovincial aspect. And I bumped up against this shared jurisdiction in flood forecasting, where the feds had a lead was in producing flood damage reduction maps, because the feds would be asked to support damages from floods. And so it became a federal provincial thing that the provinces were quite happy to support. And for many years, flood damage reduction maps were made across Canada in the early 80s. But when it comes to climate or climate change, increasingly the focus of the IPCC is on health and climate change, unlike the early years. And so there's a part of climate change that is health related. And in the mandate letter, there's no mention of climate change, but rather health, a healthy environment. So I'm wondering if the feds are going to have a part to play here, what would they go after? I think in my opinion, as a non-lawyer, would have to go after impacts that are clearly provincial or municipal. But I'd be interested in what you think of this environmental justice strategy in particular.
Well, there's a lot rolled into that question, so I'll try my best. I've jotted down a couple notes. I would say at the outset, there is a lot of renewed interest at the federal level in terms of ensuring environmental justice or access to environmental justice, and that's a key priority for CELA as well. And basically, that's recognition that traditionally poor communities or racialized communities tend to, be bombarded with a disproportionate amount of impacts. They don't share in the benefits, and sometimes don't even have access or proper access to the decision-making process. So I think that's a partial explanation why that issue showed up in the mandate letter directed to the minister. Some of you may know that during the last parliamentary session, there was a private member's bill that was specifically intended to address environmental racism, as some people call it. It basically compelled the federal government, if it was passed, to compel the government to develop a strategy to deal with environmental injustices suffered by communities of color traditionally, and then report upon ways and means to reduce or eliminate that, and report publicly on their ability to do that. That bill C-230 did not pass. Few private members' bills ever passed, and that one died on the order paper when the most recent federal election was called. So I know the opposition parties are interested in bringing it back, but it'd be nice if the federal government sort of went to the front of the queue and introduced its own amendments to CELA or otherwhere and other legislation to, again, entrench strategies and mechanisms for finally dealing with the residue or the legacy of environmental injustices suffered by First Nations and other communities across Canada. You mentioned floods, and that raised my eyebrow a bit, because when I was going through that database that I referred to earlier, that summarizes just what every climate case brought in Canada and elsewhere around the world, there was actually a case brought here in Ontario by a private individual whose land got flooded, and he sought damages from the Ministry of Natural Resources. It's kind of an interesting claim, but the last notation on the case summary was that the case was withdrawn or discontinued. So I don't know if he reached a settlement with the MNR or just gave up. I don't know, but you might see more of that kind of litigation in the future, where people who have been allowed to build in a floodplain, for example, and now they're flooded out and suffering grievous damages and can't get insured, that kind of stuff. That's not the kind of case I do, but I can see more of that happening. Whether or not the federal minister can introduce legislation to proactively deal with that, I don't know. It remains to be seen. The problem is these mandate letters tend to be vaguely interpreted by the receiving minister, and sometimes action doesn't get done in a timely way. And the good example of that is the previous environment minister had a mandate letter to entrench a public right to a clean, healthy environment in CEPA. That didn't get done. That was introduced in a bill called C-28 in the last parliamentary term, and it too died on the order paper when the election was called. So I guess the mandate letters are good, feel good statements of intention, but we'll have to see if they actually get done in a timely and effective manner. Bill, I hope that answers your question, at least in part.
Yes, and in fact, just a little further, the reason I brought up floods is that flood costs are the biggest climate impact in Canada. Something like 43% or so of damages from climatic disasters are floods. And given the past happy, harmonious agreements between the federal and provincial governments on this, I thought that would be a place to start, because it's fairly clear climate change is bringing more floods.
Well, and that's a good point. I don't think you don't have to look any further than the BC floods this year that destroyed highways and infrastructure, et cetera, to the tune of multi-billions of dollars to get it back right. And so when people say, well, can we really afford to take some of these measures on climate change? I say, can we afford not to, when we're going to be footing the bill all the time?
Exactly. Thank you.
Okay, so Dave, you're going to be next, but just a quick reminder to everybody, please try to keep your questions succinct, and we'll be able to get more people into the Q&A lineup. So Dave?
Yeah, thank you, Rick. I'd like you to expound on this. How might joint and several liability pertain to the issue of causation that you mentioned?
Okay. Joint and several liability refers to instances where you're suing multiple defendants, and the argument is they're each liable for the full extent of the damages. They can do a trade-off as amongst themselves as to apportionment of liability, but so that helps in situations where you're suing a variety of defendants. Some may have deep pockets, others not. And the one with the deep pockets might be compelled to pay the full cost of the damages that are awarded. But it doesn't really get after the causation in fact, causation in law. Did these defendants, knowingly, deliberately, or unreasonably or carelessly, do things that resulted in harm to the plaintiff? So joint and several liability is really a who pays. I don't see it as directly relevant to the whole issue of proof of causation.
I guess what I was wondering is if a plaintiff can show that, for example, he was a farmer and his wheat crop has been ruined because temperatures are too hot now, and it's a question of, well, he's blaming Exxon, and Exxon can say, well, we've only admitted 1% of all of the stuff. We see your fields can't grow wheat anymore, but it isn't our fault. Then it would seem to me reasonable, at least, to propose as the plaintiff's lawyer, well, it doesn't really matter whether you only did 1%. The fact is that you and everyone associated with this caused this, and it has happened. And my client has been injured. So I want compensation from whoever has the deepest pockets, and that might send ExxonMobil running.
Well, I think you'd name more than one company.
Oh, sure.
And that's where joint several liability really get into it. I would be also very cheeky and suggest that you may want to consider suing the responsible governmental authorities who authorize these activities.
Yep.
We call that regulatory negligence, and those claims are sometimes hard to prove. But again, there are instances in Canadian laws where municipal, provincial, and federal governments have been held liable for careless conduct or careless authorization of activities causing harm.
Right. Great. Thank you for the answer.
And generally, government has deep pockets, thanks to you and me and every taxpayer in this province.
Mhm.
Okay, so Vic, you are now, and following you will be Jeff Strong.
Well, my question relates to the legal rights of civil servant, because I was drafting regulations for 27 years with Environment Canada, a little more than that actually. And I come under a unique circumstance that found me under a multi-million-dollar lawsuit up until the year before I retired. What had happened was when we promulgated the Montreal Protocol in 1987. Shortly after that, a couple of years after that, I got a phone call, and the phone call was from somebody questioning me about what was likely to be future regulations on protection of the ozone layer. At that time, it was only chlorofluorocarbons. He said, I've been contemplating buying a franchise for this small fire extinguisher company, halons. Is it likely that we're going to be regulating halons? And I said, well, let me just acquaint you with the science here. Halons are 32 times more destructive than chlorofluorocarbons. And the only reason chlorofluorocarbons are being regulated first is because the quantity of them are so much greater. So the impact, of course, is the ozone depleting potential times the quantity. And in that case, CFCs come first. But I said, yes, they're definitely number 2 on the priority list. So, but I don't know, shortly after that, I get a phone call asking me to appear on Marketplace television show. And they said they just wanted to talk about the repercussions of the Montreal Protocol on business enterprises. So I get up there and they introduce the Entrepreneur of the Year award winner. And this was the guy selling these franchises. So then they brought me out, and the speaker said to me, what right do you have as a civil servant to destroy this man's business by offering this kind of advice to people who call the government asking for reflection? So I was told by the Justice Department that there was now a lawsuit pending on me and people above me that had allowed me to speak this way, claim. Okay. And the Department of Justice also came and interviewed me and said they weren't sure if I'd exceeded my rights as a civil servant. Okay. And therefore they weren't sure whether they're going to defend me or not. So in 1993, when I was a technical negotiator for the Earth Summit, and we had a lot of highfalutin politicians there, Paul Martin and a bunch of others, I was invited to lunch with them. And I told them over lunch that I was under a lawsuit. And they thought that was ridiculous. That was ridiculous. And they bring it up in the House of Parliament if it proceeded. Okay, so when I get back, then Department of Justice contact me again. They want to update the case against me. What did you say on the phone? How long did you talk? All of this kind of stuff. But the irony of it is, I wasn't even sure if I would have legal support from the government here. Not at all. And it was really a thorn in my side right up to the year I retired. And then the Department of Justice finally contacted me and said the case has been dropped. And that's because we already had legislation in place regarding halons. So I just asked, it just seems to me a vague part of the law. What is the rights of civil servants? What are they not? Defending the environment.
Okay. Well, let me repeat my earlier caveat. I'm not here to give legal opinions via Zoom. And that was very interesting, but disappointing tale that you told. I'm sorry to hear that it happened. It caused you so much grief. I'm also surprised that there was a threat to sue you personally, because there is case law indicating that governments are vicariously liable for the acts and omissions of their agents and servants, and presumably you're acting within the scope of your duties. So that may be an explanation why this litigation never went forward. So I think that's all I can really safely say without knowing more. But I'm glad you dodged that bullet.
Thank you. Thank you for your presentation.
Okay, so Jeff Strong and then John Hollins.
Yeah, thank you, Rich. Oh, wait a minute. Let's. All right, there we go. Thank you, Rich, for a very informative talk. I didn't know there were so many cases that have gone to court in Canada involving climate. But my question is, it regards the public plan that was released by the federal government in December of 2020, wherein they say the government of Canada has already achieved a more than 34% reduction in emissions from federal facilities and conventional fleets, and is on track to meet the 40% target by 2030 or sooner. That's fine, except in public announcements and that they don't mention the caveat from federal facilities and conventional fleets. And I've heard Prime Minister Trudeau say this many times, and of course it was said at COP26. So the question is, could an organization take the federal government to court because it used deception in its climate plan?
Yeah, well, that's not unlike some of the greenwashing litigation that we've seen south of the border and here. You know, you probably are aware that, you know, from time to time, environmental groups have filed complaints with the Competition Bureau saying, you know, this company or that company's made a misleading statement. I don't think that remedy is available with respect to federal pronouncements. Again, for the reasons of justiciability, you know, if you're taking the position that they're misstating or misrepresenting, you know, their actual, you know, compliance rate or reduction rate, that's really a political matter. I think most judges say, you know, get out of here, take it up with your MP, take it up with Parliament. I don't, you know, I'm not here to get legal advice again, but I think there are some built-in barriers to bringing that kind of claim in court.
Okay.
Sorry to disappoint you if you're intended to go to court. But
No, I wasn't intending.
I would also, when we advise clients on the threshold question, should we go to court or not go to court? Often going to court is the last resort. We try to exhaust all our other remedies because going to court, you know, it's lengthy, complex, it's costly, it's uncertain. So, you know, in your particular case, there may be other ways and means to hold the government's feet to the fire in terms of its extravagant claims about how well they're doing without going to court.
Gotcha.
Okay, John Hollins and then John Mayer.
Thank you very much for broadening even further than it already was the range of topics and interesting subjects that these CACOR Zoom series look at. You've really widened our perspective today. I want to go back and remember that in the late 80s, 1980s, global heating got on the political agenda in Canada and to a very minor degree on the public agenda. It took 3 decades and a young Swedish activist to get it much higher on the public agenda and on the political agenda. Now, I don't know anything about the courts, but I presume that those who service on courts are thoroughly aware of what's going on in the society year by year. How, if at all, does this kind of evolution in broad understanding of the source of global heating and its broad consequences trickle, if I assume correctly, how does that trickle into the thinking and perhaps the decisions of courts?
That's a good question. So we have, I guess, a theory or an approach that allows courts to take judicial notice of things that are, you know, manifestly true, way beyond dispute. You know, the fact that the sun rises in the east, you don't have to prove that as a matter of evidence at trial. A court can take that into account. But where things are in dispute, you know, whether it's the nature and extent of, you know, climate change impacts on the ground or who causes it, that still requires proof. You know, I think a judge can, as Chief Justice Wagner did in his opening comment that I reproduced in front of my slide deck, I think a court can tip its hat to the fact that, yes, global warming, climate change, is serious. It's happening now. I don't think that requires much or any proof. But then if you're trying to hold somebody accountable for that, you're saying, these five big oil companies or fossil fuel companies, they materially caused the risk. And now, the chickens have come home to roost. Now we're being impacted. They profited. Time for them to disgorge some of their money. That would have to be a matter of proof. I don't think the court can take into account on the basis of judicial notice that, these five companies did things or failed to do things, and that resulted in harm to this plaintiff or that plaintiff. That's a matter of proof.
When I look as a lame person at stories about the legal system and cases and judgments, it looks horrendously slow. But I have to say that when I look at the performance of the government of Canada on global heating, it's even slower.
That's a good observation.
Thanks.
And John Meyer, I'd be surprised if you don't have a good question.
Yes, thanks. This certainly broadens our outlook into an area I would hate to get involved in, which is the legal aspects. But we recently, Canadians for a Sustainable Society, recently made a presentation to Aurelia, which is looking at how to implement the province's growth plan. And that will involve expanding Aurelia's borders because they're going to get more people. And Aurelia commendably has set up a very transparent program that asks for public input and both in terms of a survey and also in terms of an open mic forum. In all cases, it showed that Aurelians wanted, unsurprisingly, affordable housing. They didn't want an increase in congestion. They wanted a healthy environment. All of these things are diametrically opposed to or negatively impacted by growth. No surprise. But as it turns out, Aurelia can't say no, or they feel they can't say no to the government growth plan because it's been mandated federally and provincially, and it's driven by levels of immigration that's going to triple our population by 2100. And that's what the trajectory we're on. My question is, both this whole process, there's no democratic really input to it, although you can say it was established by elected governments, but it's certainly not democratic at the local level. And also the environmental impact has been completely evaded. The process of assessment has been completely evaded. What could individuals, organizations, and municipalities, because they're getting, Hamilton has certainly taken up the cause against more growth.
Yep.
What can these people do to take on an embedded strategy that was implemented in 2005 and is sort of a leftover from the 1800s?
Well, you put your finger on a really, really compelling problem here in Southern Ontario, which is, whether or not it's a good idea to lock us into more sprawl, which again requires more highways, more cars, more congestion. Should we, if there are, population increases that are coming, can't we accommodate that through infill as opposed to expanding into the hinterlands and gobbling up farmland? So I guess I'm of two minds or two views on how to respond to that at the local level. Number one, keep in mind, I think it's this year's a municipal election year. So hopefully you'd want to have a slate of candidates that could be voted in that might reverse or oppose some of the stuff. Just as you pointed out, the city of Hamilton has attempted to draw the line in terms of expansions of the urban boundary. And that would be something I'd encourage other municipalities to do as well. I guess the other thing is, some of these land use planning decisions may ultimately require plans of subdivision or other statutory approvals under the Planning Act, Greenbelt, etc. There might be opportunities for appeal to the Ontario Land Tribunal. I don't really know because it depends on how this, sprawl gets planned and implemented on the ground. So that might be an option to be on the lookout for. But keep in mind, going to the Ontario Land Tribunal, formerly the OMB, that could be as tedious, time-consuming, costly, and uncertain as a court action. So you'd have to, be careful what you wish for, even if there isn't an OLT appeal opportunity. People will have to be committed to actually raise the money and hire the experts and hire the lawyers to do that. I guess the other thing is a lot of this rampant interest and sprawl in the sort of the northeast and west of the GTA. A lot of that's precipitated by the issuance of ministerial zoning orders under the Planning Act. The provincial government got some backlash from the public about the overuse of some of these ministerial zoning orders, particularly where the local council hadn't even asked for it. So that'd be, again, something I would say in general it might be a good strategy. Make sure that your councillors are not, behind closed doors asking the Minister of Municipal Affairs and Housing for a ministerial zoning order that allows, more development to occur without proper vetting, public notice and comment or appeal. Those are some of the things that we look at when we do some land use planning cases.
Yeah. Okay. Thanks very much.
So Bruce Fanjoy, you're next. And I was going to have Dave Doherty after that, but I don't see him on the screen. We'll just wait and see. And if he isn't there, then Jeff Strong, you can have a second question. Oh, there's Dave. Okay, so it's going to be Bruce Fanjoy and Dave Doherty.
Can everyone hear me?
Yes.
Thank you, Rick, for a very thought-provoking presentation. I appreciate that. I'm curious, how much legal weight do rulings outside of Canada have on Canadian courts?
That's an excellent question. The short answer is they don't have any binding effect, but they may well be persuasive. And that's why we, will bring in decisions from other jurisdictions, whether it's United States or, European courts or international courts for that matter. They're not, strictly speaking, binding on courts in this country, but, the legal analysis, the approach taken, et cetera, and these other judgments might be of interest, and they may, to judges here, and they may adopt it. So that's why we bring that stuff forward.
Thank you.
So Dave?
Hi, Rick. I was wondering, for future laws and amendments, could justiciability be specifically included in the text of said laws?
Sure. I mean, legislatures can say whatever they want as long as they're acting within the jurisdiction. So they could put in a caveat or disclaimer that says, none of this can be, kicked out of, if there's an action that's undertaken that involves the subject matter of the legislation, it cannot be dismissed by the court on the basis of justiciability. I don't know if a legislature would be prepared to go that far. In fact, they would try to immunize themselves from scrutiny or review by the courts. So they probably would not want to put that in because that would seem to open the doors to what they call a floodgate of litigation. And I think they would like to preserve the opportunity to argue justiciability in order to keep the thing out of court.
Thank you.
Okay, so Jeff Strong?
There we go. Rick, this isn't a legal question so much, but it refers to one of your final slides where you said, well, I'll give you the question. How can CEPA, and I don't remember what CEPA is, and others, list carbon dioxide as a toxic substance when it's essential for life on Earth, right? For photosynthesis and for maintaining the climate at a reasonable level. I'm surprised that gets out there. And a lot of people regard carbon dioxide as a pollutant, and it is not a pollutant. I try to emphasize that in my talks.
Yes. There's a very, first of all, CEPA stands for Canadian Environmental Protection Act, and the centerpiece of that legislation is this fairly rigorous review of substances to determine whether they're toxic. And it doesn't mean they're inherently toxic or poisonous. It's simply an assessment by scientists with input from others, whether or not this particular substance is entering the Canadian environment in amounts, concentrations, or volumes that could cause harm. And so I think, I haven't read the assessment report for CO2, but I suspect they basically said, yeah, in small quantities, it's fine. It is an essential building block for life as we know it. But when you're putting gigatons in the atmosphere, that's a bad thing. So maybe I'll just stop it at that. I will commend you because during the Supreme Court of Canada hearing on the Greenhouse Gas Pollution Pricing Act that we all did last year, that very question was put forward by one of the justices, who told one of the lawyers at Lindgren, "You're breathing out CO2 right here, right now."
That's right. Very good.
Meg Sears.
Yes. Hi, Rick. Thanks so much. This is a great talk, and thanks for your tremendous work over the years, and also for helping us out preserving a wetland a long time ago. My question has to do with the right to a healthy environment within CEPA. In the last parliament, they actually put forward amendments and then sort of sat on it or left it in a corner or something. And so it didn't really see the light of day, but the right to a healthy environment was in the preamble. And so I was wondering if you could comment on the difference between being in the preamble and somehow being within the text of this humongous piece of legislation, which is CEPA, and how that could be sort of operationalized.
Yeah, thanks, Megan. It's good to see you again. Well, as a matter of law, what is said in a preamble has no legal force or effect. It's not enforceable. It sort of lays out the policy basis for the legislation for the text that follows. So at best, it's an interpretive aid, but it doesn't really confer any enforceable rights. So then we looked at what the government was proposing in Bill C-28 in terms of the actual right that was going to be superimposed on CEPA, and it came up way short. It was so qualified and full of weasel words. And I tell you, as a lawyer, I know weasel words when I see one or see them. And it wasn't going to be a very good or effective right at all. I prefer my substantive right to a clean and healthy environment to be expressed in clear, concise terms. Some people have argued, that kind of right should go into the charter. And some folks like Professor David Boyd from BC, who's now a special rapporteur on human rights and the environment at the UN. He's put together, a really, good one-sentence statement of what a substantive right to a clean, healthy environment should look like. I would prefer that to the mishmash of stuff that we saw in Bill C-28. And my concern is that when Parliament resumes and when the CEPA amendments are reintroduced, we're going to get the same gibberish, which really won't get us too far in the right direction. And if anybody on the Zoom call today is interested in that, if you go to our website, CELA.ca, we have a lot of analysis about CEPA, but some of our most recent work deals with the various procedural and substantive shortcomings of what the government was proposing to do in the last parliamentary session. So we'll see what they do with this one, but what they proposed before was completely ineffective. And unfortunately, some environmental groups saw the work, saw the commitment that there was going to be an environmental right of some sort bestowed upon the public in CEPA. But you need to read the fine print. The devil's in the details. What they came up with was, wholly ineffective and totally unacceptable. So hopefully they do better next time.
Yeah, we'll have to touch base on that because we've been working on if there was a right, what would the science look like? How would you put wheels on this and make it happen in the back end? So, but okay, well, thank you very much for that clarification. There's lots of work to be done on that issue as well.
Yep. Agreed.
Okay, so Peter Meinke, you're next. Ted Manning, and I just have Bill Bland making a comment. So Bill, if you want to be third, then you'll have time. Peter.
Oh, hi, Rick. Thanks very much for that wonderful overview of this tremendous activity to fight climate change. I knew a little bit about it, but that was a wonderful overview and lots to learn. My question is very brief, and I also, I'm not sure you can answer it because it may be something that, at any rate, it's the federal government is spending a lot of money subsidizing fossil fuels. It's our money. I know we can try to influence it by votes, etc. But is there any way we could actually sue the federal government for its subsidizing fossil fuels, even on the basis of they're using money that should be going into healthcare?
Yeah, you know what? And I think that kind of litigation would run headlong into the justiciability problem.
Yeah.
That's the concern. I mean, if we had a charter right that guaranteed everybody the right to a clean, healthy environment, however you define it, maybe you could use that as you know, a sledgehammer to go after governmental programs or policies that allow for these large amounts of, you know, subsidies to go to, you know, these various companies that we should be phasing out, not subsidizing. But we don't have that charter right. So I think at least for the interim, the best attack is to keep up the political fight at all levels, saying we need to wind this down. It's just, you know, in fact, you're probably more familiar with it than I am, but I think I read something a couple of weeks ago indicating that in terms of per capita subsidies to oil and gas, Canada is at the top of the list. And I don't think that's, I don't think we want to be number one of that parade.
Yeah. Thanks very much. Yep.
Okay, Ted, do you have a comment? Ted Manning? Looks like you're muted.
There we are. I'm just going to follow Peter's comment. There's a lot of tools, at least are feasible out there, and I just wanted to raise a couple. I've heard the notion of class action suits to take on specific environmental issues, and climate change may be in that, and also writs of mandamus, where government is found not doing the job that it in fact is being paid and mandated to. Do these work?
Well, class actions against the federal government here in Canada have not worked so far. That doesn't mean they might not work down the road, but keep them like people read a lot about class actions, mostly because of some of the extensive class action litigation that occurs south of the border, and you see it on TV, you see it in the movies, and you think it's a wonderful mechanism, but it's actually difficult because, as I mentioned an hour ago, you can't proceed as of right with the class action. You have to persuade a court that this is, you know, effective and efficient mechanism to bring forward claims that otherwise can't be brought by individual claimants, mostly because the monetary levels are so small. Nobody would spend $50,000 to recover $5,000. But if you had 50,000 people, each of whom were out $5,000, that makes a class action more viable. But, you know, here in Ontario, we have something called the Class Proceedings Act. It's got a fairly strict test as to when you should or should not be certified. And I don't know if you saw this in my bio. I was actually part of the advisory committee that drafted that class action legislation here in Ontario, because I thought it was going to be really user-friendly, and I thought it'd be used as a basis for advancing all kinds of cases where there's been mass environmental harm. That has not been the case. It's been pretty tough for the most part to get class action certified on the environmental front here in Ontario. So I think there's room for further reform. So class actions are out there, but, and again, to use the phrase I used earlier, they're not a cakewalk. There's a lot of additional procedural steps that have to be taken, a lot of uncertainty about whether you even get through. Now, having said that, Quebec has a class action certification process and criteria to be used, but it's also generally the cases tend to go forward unless there's a really good reason not to let it go forward as class action. The exception would be the Anjou case. People are kind of surprised that did not get certified. The other mechanism you mentioned was writ of mandamus. That's usually a remedy that might be argued in a judicial review application where you say the government has you know, committed a legal error or exceeded its jurisdiction in doing thus and so, and they should be ordered to do something. That's what mandamus is. It's used for situations where the government owes the plaintiff or the claimant an express duty to do something. So it's not, so you can't use it to go after the government for, you know, doing or making them perform obligations that's owed to the general public at large. It's instances where someone has a specific obligation or duty owing to them from the government, and it hasn't been performed and you're asking the court to make them do it. Sometimes hard to get. Sometimes the courts are just content to just simply declare that the government should do this and that, but they don't actually direct them to do it. And sometimes in the court's discretion to say, you know what, you're right. The government did have a legal duty to do this or that, or to not do this or that. But we're not even going to grant you a remedy. We're not going to step in. But that's most unfortunate when that happens, where you're right, or the plaintiff is right, but you don't even get a remedy from court. That's happened from time to time. Sorry, Ted, I don't know if that answers your question, but and I'm not discouraging people from considering legal options. You know, lawyers are people too. They need to work, they need to eat, need to send kids to college. But sometimes there may be better ways to go after it, because nobody wants to go to court, lose a high profile case, set a bad precedent, and end up paying legal costs to the other side. That's not a good day.
Okay, so Bill Bland, you're going to be next. Meg Sears has another comment. I'll give her an opportunity to explain it. And then I've got a quick comment, and then Ted will do the wrap up for the session. And we're getting pretty close to 3:30 and just about on time. So Bill Bland.
Okay, all I wanted to make the point for in that comment was that it's the arguments for or against things like toxicity, of carbon dioxide don't really make any sense at all. Concentrations of whatever material are around is what causes things to be toxic or not. Actually, CO2 just gets in the way of things you do need to breathe. Fine. There's CO2 in your body on a natural level, in balance with everything else in the system that involves the CO2 and its reactions. You're just keeping a balance by breathing the excess out that's produced within your cells all the time. Actually, 100% CO2 will probably be possible to define as toxic. If you were in 100% atmosphere of CO2, you wouldn't have any oxygen around. But then you could say the same thing about water. Do we have to be that careful about water as well? End of comment?
Okay, well, I appreciate your comment. Obviously, I'm not a toxicologist or a scientist. I just have to defer to the federal regulatory decision that CO2 is potentially toxic. It could be regulated in terms of its emissions. I suggest that you take that up with the government. But that decision was made long ago. And I didn't make it.
It could be regulated, and too much or too little is a different argument from saying it's toxic or not. That's the only problem. It's the terminology.
Yeah, but that's what I was trying to clarify earlier. A finding of toxicity under CEPA doesn't mean it's inherently toxic. It means it's based on whether and to what extent it's getting out into the Canadian atmosphere.
Right.
Okay, are you still there, Rick? I think we've lost Rick.
I think the answer to that is yes, potentially.
Okay, Meg, you want to wade in here again?
Rick, can you hear me?
Yes.
You're sort of coming and going, that's all.
Okay.
Okay, thanks so much. Very briefly on the carbon dioxide being breathed in, there are levels that about 3 ppm, or I believe it is, that start to be toxic because of acidity in the blood. So certainly we could not possibly be existing even if we had adequate oxygen in a very high CO2 environment. But that's, as you say, that has nothing to do with the toxicity to Earth. I thank CELA for tremendous work on amendments to CEPA and so on. They've really carried the flag in the current version of CEPA way back in the 1990s, and have done tremendous work. Our group, Prevent Cancer Now, is more science-based. And so we've started to put our minds to what the science would look like to operationalize a right to a healthy environment within the context of chemicals. Because not only do we have CEPA coming up, but also the Pest Control Products Act should be before Parliament because of the MRLs. There was an issue before the before the election. So they promised to bring these 2 chemicals laws. And I talked about that a few weeks ago. But our group actually has a letter that you can, is a nice background letter on our website. I put the link there, and it is editable, and you can send it automatically to ministers and critics for health and for the environment. I just wanted to point that out, and I'm sure that we'll be touching base more on this important issue, because if we don't do it now, when we've got these 2 pieces of legislation, then we're going to continue to have sort of disparate, unconnected, inconsistent science.
Okay, well, I look forward to that future input.
Yeah.
Okay, so I'm going to go back to the introduction, Rick, and we sent you a copy of the charter that we're working on. And I was just wondering whether you had a chance to peruse it and have a comment about its applicability, its likelihood of changing things. Most of the people that are on this call have received a copy of it, so that I think that you can comment as you see fit.
I told you not to cross-examine me or put me on the spot. When I did look at it, you were kind enough to send me the documents. And I would say for the most part, they articulate and advance some really good ideas that need to be implemented ASAP, especially on what we were talking about a few minutes ago, the phasing out of subsidies to oil and gas development and exploration, and funneling that money towards workers and otherwise ensuring a just transition. That's an important objective. So there's a lot in the charter that I would agree with, and commend you for flagging this stuff and using all the means at your disposal for advancing that agenda at the local, municipal, regional, provincial, and national level.
Okay, well, this wraps everything up. My superb thanks for your presentation. Really nice to hook up with you again after a long missing of you. Can I say that?
Well, Phil, let me just say we've let 30 years go by. Let's not let another 30 years go by.
Yeah. I'd like to go and see your home down on the island someday.
Well, you're looking at the kitchen wall right now.
Yeah. So anyway, Ted, you have some final wrap-ups to offer us?
Yes, simply to thank you specifically. Dave has a screen thing here we try to put on for everyone, to thank you all for coming. And we're really very pleased at how this series is going. We'll be reaching nearly 100 presentations in the next month or two, and it seems to be growing. We are getting people coming in from time to time from elsewhere. The commercial is that those of you who are not members, we would very much like you to join us. To take the commercial further, it's going to cost you less than a tank of gas to belong to CACOR for an entire year, to hear all of these wonderful presentations like the one Rick has done today, and also to make it available around the world. And we've had, in some cases, over 7,000 views of a specific presentation, and most go well into the hundreds. We are making a difference, and we need your help to make sure we keep doing it. So again, thank you very much, Rick, and I'd like to thank you on behalf of CACOR for helping keeping us relevant and on target and maybe making a difference. So thank you again.
Okay, well, thank you very much. It's been a pleasure to be part of this dialogue, and I want to wish you good luck in your future endeavors.
Thank you.